Hello and welcome to this week's edition of Rights and Recourse, a show that brings you information on and analysis on legal matters and issues affecting your rights. My name is Dubile Matez. Remember, you can also be part of this show by calling us on 011 714 5497 or 5498 at Rights Recourse, or email your thoughts to rightsandrecourse@sabc.co.za. There seems to be no end in sight in the tensions between the South African judges and the country's politicians. And today's media carried the latest criticism of judges by leading politicians. This is after they requested an urgent meeting with President Zuma to discuss concerns over continued attacks by politicians. Before discussing their ongoing standoff, let's take a look at this report by Lukhanyo Kalata.
The judiciary, the executive and the legislative, tasked to co-govern the country without encroaching on each other's spheres. But this relationship has come under increasing strain, largely due to scathing criticism of the judiciary from both tripartite alliance leaders and some cabinet ministers, prompted by at least 3 High Court rulings against Parliament and more recently the al-Bashir judgment. While some degree of tension between the 3 spheres is normal, the current level of animosity is seen to be cause for concern. Government has moved to allay fears of a constitutional crisis.
Those who say there's a constitutional crisis have it in their heads. There is no constitutional crisis in the Republic of South Africa. What there exists is a robust discussion and engagement that we want to have with the judges. So I will say to Chief Justice Mogoeng, Chief Justice, we welcome your call to meet the President, to meet the Executive, so that we can have a thoroughgoing, robust discussion about your role going forward as well. And by say role going forward, the independence of the judiciary is something that the African National Congress will defend at all costs.
In a statement, President Zuma recommitted himself and the executive to the independence of the judiciary, as well as to the further strengthening of good working relations. The president will attend to the request for a meeting with Mogoeng when he returns from the BRICS summit in Russia over the weekend. Lukhanyo Kalata, SABC News.
Well, to further discuss the ongoing spat between the South African judges and the country's politicians, let's welcome political analyst and Wits Vice-Chancellor, Professor Adam Habib. We are also joined by Lwando Xaso, a constitutional expert, and from our Seapoint studios in Cape Town, we are joined by Lawson Naidu from the Council for the Advancement of the South African Constitution. Ladies and gentlemen, good afternoon. Welcome to Rights and Recourse.
Thank you for having us.
I want to go back into that clip by Deputy President Ramaphosa took us straight to the separation of powers doctrine. When you answer that, Prof, let me start with you. When you answer that, I wanted to answer it with something else that I had written. There has been some very strong assertion, especially recently by the chairperson of the National Council of Provinces, Ms. Thandi Modise, that the judiciary is interfering in the work of Parliament. Surely, if there's something wrong with what is happening in Parliament, the judiciary is the only place to which to run.
So I think that, look, I agree with Deputy President. I don't think we have a constitutional crisis. I think we're far from a constitutional.
But might have it later.
We might have it later, but at the moment we don't have a constitutional crisis. We have some politicians who are irritated because the courts are dealing with matters in ways they don't like. That's not surprising. We've seen this before in South Africa. We've seen this in many other countries. What I think, I'm quite glad that the judges got together and said they want a meeting with the president. I think it's a wonderful sign. It's a sign of independence, ironically. It's a sign that they're making very clear that they're not going to be bullied, and that should be the case. So I don't think we have a constitutional crisis. I do think that some of the politicians have to watch out how they're criticizing. Their legitimacy to criticize is sacrosanct. What is the problem is how you criticize. You must be able to think through the criticism. You don't take pot shots in generic ways. You have to recognize the way a citizen criticizes judges should be different from the way the Minister of Police criticizes judges. And when a Minister of Police says the judge met somebody quietly and was influenced in the decision without proving evidence, that should be an excuse for the barring of the Minister of Police, because that's an irresponsible statement. But I don't think we're in a constitutional crisis yet, and I don't think we should start panicking at this point.
I think it's more of a constitutional discussion. And I also think what we have to keep in mind is that part of constitutional theory is having arguments about our constitution, our common constitution. And I think through those arguments, we're showing a dedication to some kind of a constitutional enterprise. So for me, it's rather a sign of vitality. It takes years and years to realize the kind of society that the Constitution requires from us. It doesn't happen overnight, and you have trial and error. And it's a long journey, and through that journey, I think at times it's okay to feel dispirited.
Lawson down in Cape Town, I was actually intrigued by a statement by Deputy President Ramaphosa there saying, we welcome your meeting with the President, and we also welcome the fact that we want to have a discussion with you also about your role. Isn't that role encompassed in the Constitution?
Indeed it is, but before I talk about the role of the judges, I think it's important to talk about the terms of engagement that the other two panelists have commented upon. I think an engagement between the three arms of the state is very important and healthy in a vibrant democracy, but the terms of that engagement is what is important. If it's an engagement between the executive and the legislature, both of which are inhabited by political actors, then a robust discussion is perhaps inevitable. But when it's a discussion by either the legislature or the executive with the judiciary, I think that the tone of that discussion needs to be more tempered and demonstrate a lot more respect, given that we live in a constitutional democracy in which the courts are the ultimate arbiters of constitutional powers.
What do you mean?
So I think, having said that, it's a welcome development that the judges got together earlier this week, and I think they've taken a very brave step. I think, as Adam Habib has just said, I think they've exerted their independence and exerted their autonomy and want to engage with the politicians, with the President, to deal with the statements from politicians that have the potential to undermine the independence of the judiciary and the respect for the courts.
Let's first deal with this issue of separation of powers, the separation of powers doctrine. What do we actually mean by that?
I mean, when you talk about separation of powers, I like to explain it in a way where I think lay people, the general public, can understand it. So, for instance, if you have an issue with your boss, you wouldn't want him to act in that capacity as your boss and as someone who's going to determine that argument. You need a third party that's impartial. So separation of powers means that state power is divided into three arms of government. The executive, which is the policy-making branch, the legislature, which makes our laws, and the judiciary, which adjudicates. And there are a number of reasons for that. One of them is efficiency, the other it's functional. But the bigger reason for that is that if you accumulate too much power in one branch of government, that could lead to some kind of tyranny, and that's what we're trying to prevent. But I think the most important part to remember is that no separation of power could ever be complete. You can never have an absolute separation of powers. There are gray areas, and those are the parts right now we're trying to navigate, I think.
It seems to me that what we're trying to avoid is a situation where somebody is player and referee. What you don't want to do is to be making the laws, implementing the laws, and as you implement the laws, when a citizen takes this to court, you don't want to be the same person deciding on what the outcomes are. That's why the separation of powers is there, is to ensure that there's a certain set of rights that are accorded to citizens, to make sure that those rights are fully realized in any context of implementation, and this is meant to facilitate that. So I think that's what the purpose of it is. There's always gray boundaries. There's always going to be cases where people are going to differ on a particular decision. And in a democracy, that should be the case. And I don't, for one, take the position that says that the lawyers and the judges cannot be wrong. there's been many cases when judges have been wrong. What I want to be able to do is engage those judges and criticize those judges and reflect on that. But if I'm a leader in the cabinet, I have to do so within particular parameters. I must do so without threatening those judges and threatening the judiciary's right to be the neutral arbiter that it's meant to be.
A view that's coming very strong from Professor Habib, but for now, let's take a break, a net break. But before, let me remind you that you can also be part of our discussion on 011-714-5497 or 5498. You can also tweet us at Rights Recourse or email your thoughts to rightsandrecourse@sabc.co.za. Stay with us.
Of our world, a better one for all.
Welcome back to Rights and Recourse. So I want to go back to Cape Town, but before we continue our discussion, let's hear from the Chief Justice Mogoeng Mogoeng, who had to say about this spat.
Everybody, whatever her or his status, is subject to and bound by the Constitution and the law. As a nation, we ignore it at our peril. Also, the rule of law dictates that court orders should be obeyed. Our experience by and large is that court orders have been honored by other arms of state. The few instances of where court orders have not been complied with, whatever the reasons, have the effect of undermining the rule of law. The heads of court and senior judges of all divisions have requested the Chief Justice as head of the judiciary to meet with the head of state to point out and discuss the dangers of the repeated and unfounded criticism of the judiciary. Criticism of that kind has the potential to delegitimize the courts. Courts serve a public purpose and should not be undermined.
Well, that is the Chief Justice of the Republic of South Africa. I want to go back to an issue he raised very strongly. And that issue, I want to tie it up, Professor, with a statement made by President Mandela delivering his budget vote in 1998, where he says the independence of the judiciary is one of the pillars of our democracy, and equality is fundamental, is the commitment to abide by decisions of the court. Where did we go wrong?
So I think that that's absolutely right. I think the Chief Justice is absolutely right when he says that government has to obey court orders. Now, for instance, I was very critical of the ICC, and I have been. I've also was critical of the lawyers that took up the case. Nevertheless, once the court pronounced and gave a court decision, it should have been obeyed. And I understand the complexities of politics that would have created. I understand the contradictions in international relations and the problems that it might raise. But I think that what had happened there is once there was a court order, we should have actually abided by it, because not to do so, and there have been one or two other cases as well, undermines the rule of law, and it undermines one of the fundamental pillars of our democracy. And I am worried about that. That doesn't mean we can't criticize the ICC. It doesn't mean you can't criticize the Southern African Litigation Center for the legal actions that they took. But once a court order is done, you have to stand by it.
I mean, can I just push back a little bit on that? And I feel like when you say, where did we go wrong? It's conclusive. We've gone wrong. And I feel like we have to interrogate that a little bit. We need a little bit of nuance and a broader picture of the judiciary, because it's not just 3 political cases that have happened. It's a much bigger machinery where ordinary South Africans present their cases on a variety of things, where you have court orders, judgments being issued, and there is an element of enforcement. And I think we should just interrogate that a little bit, that it's still a bit premature. As I understand, there's an appeal process going on, so it's still an ongoing conversation, and this is an unprecedented case, which are normally more difficult. It's uncharted, and I think this is a great opportunity for the judiciary to give some guidance, because sometimes when you do have powers, you haven't interpreted them to that extent where you can think of a situation like this and predict what you're going to do. So I think this is an opportunity.
Lawson, if you want to come in there, I would appreciate if you want to come in, just indicate to us. I want to go back to this issue of the rule of law. What is the rule of law?
The rule of law is about everyone being equal before the law.
Okay. You can continue, Lawson.
Yeah, it's about being equal before the law. It's about everyone respecting the law. And I think that, the point is that in a democracy such as ours, there is nobody that is above the law. The courts are there to adjudicate disputes, and they are bound only by the Constitution and the law, and must exercise their functions without fear, favour or prejudice. In the al-Bashir case, the court came to a very clear legal argument. Whatever the political arguments that may be around the ICC and the role of the litigation, as Professor Habiba said, the court made a ruling on the basis of the law that was presented to, that it had to apply, and made a very clear ruling in that regard. And I think the issue around the meeting between the judiciary and the president, a lot of the criticism that has been directed at the judiciary has been gratuitous, very broad-ranging, making very serious allegations of collusion and so on, and a conspiracy by the judges. I think those are very irresponsible statements that are being made. And if anything, it's the judiciary that ought to be more frustrated with government's failure to, on several occasions, and not just in the case of the al-Bashir matter and 1 or 2 other cases, but if you look at a whole range of socio-economic rights cases where government has been very loath and slow in implementing orders of the court. And for example, we see as a result of that there's been a trend towards courts making orders where structural indictments are issued, whereby the courts are actually supervising the implementation of the court orders because they're not in a position to trust government to do so. And I think that is a reflection of the manner in which, in some cases, not in all, in some cases, in which government officials respond to court orders.
Prof, you wanted to come in there?
I just wanted to say, on the al-Bashir case, because it's such a big and important case, and it's going to be such a definer, one of the ways out of the problem would have been if government had changed, if it had its act together. It should have known long before that when al-Bashir comes to the AU summit, it's going to have a problem. It should have acted and ensured that it passed legislation or revised legislation to enable it to do what it did. Instead, what it did is it forgot to do all of that. Suddenly, 3 days before, realized, well, oops, we're in trouble. This might create problems for us. Then it tried to hastily gazette something, and it didn't meet the constitutional test. That's why we had the problem. People in government were just not on top of their game. And that's why we had the mess that we did.
Londo, one of the discussions I had with several other people, and I came up to the point that it is no more about the al-Bashir case, the Omar al-Bashir case. It's about the rule of law, really.
Well, just to go back to your earlier question as to what is the rule of law. So the way that I define it, there are 3 components. First of all, you must know the law. It must be publicly available for people to understand what the rule is that they're supposed to abide by. And then it has to be equally enforced. It goes back to the earlier point that we're all equal before the law. And the third part is you need to have independent adjudication of it. So I think with every single case that comes before a court, it is about what are the powers that the Constitution gives in this case, how do we exercise them, and what are the limits. And I don't think it's just specially to this case that the rule of law is implicated. It's in any legal case. So I do agree that it is a generic rule of law issue.
Prof, we have seen in the past that the criticism of the judiciary had racial undertones. In other words, if a white judge makes a ruling, we are told it's an apartheid judge. We need to transform this judiciary. Now that we have the majority of judges black, we still criticize the judiciary.
Well, that's right. And look, we shouldn't not expect politicians to sit to criticize the judiciary. You have that in the United States, you have it in the UK, you have it in every single country in the world. Politicians don't like it because it cramps their style. So that's what we should not be surprised by. What we should demand of them is that if they want to engage and if they want to be irritated, they need to do so within legitimate parameters. As Lawson said, you can't make the kinds of insinuations that our politicians have been making about these judges. Mercifully, this debate is not being racialized. Half of the people on that court have spent far more time in the liberation movement than half of the politicians. So that you can't make those kind of arguments against them. But it's worth bearing in mind that this is not being racialized for now, but we do have these tensions, and these tensions are going to continue. And hopefully, as we have these battles, as we have these engagements, we're going to chart the parameters around which this conversation happens. The only thing that I would ask is in that conversation between the judiciary and the executive, that conversation is transparent. Because both for the legitimacy of the legal process, both for the legitimacy of the courts, I would like to see a fairly explicit statement coming out that said, this is what we spoke about, this was the debate, this is where we disagreed, that's important.
Well, Professor Habib there saying that discussions between the executive and the judiciary should not take place in smoke-filled rooms, rather. Remember, you can still participate in our program on the 011 714 5497 or 5498, or email us at rightsandrecourse@sabc.co.za. You can follow us on Twitter at rightsrecourse. Please join us after the ad break. Welcome back to Rights and Recourse. We are still continuing discussing the issue, the spat between the judiciary and the executive. Let's go to a call on the line from Andile, the Eastern Cape. Andile, good afternoon and welcome to Rights and Recourse.
Rule of law. Then foreign policy. South Africa. Now, if you know what is major and what is always important, into crisis, the judges, decisions, the cabinet, as well as the parliament, where goes balance or arguments. After South Africa, like I can argue if South Africa is in bad partial. bese abantu abagcine ucwango abangamajoni eSudan as we speak ngebabulawayo and ngesa-declare war with ilizwe laseSudan. Now how do you balance izinto ezinjalo?
Thank you very much, Andile. What Andile is actually saying is
the tension.
The issues that if a court were to, if al-Bashir were to be arrested, President al-Bashir were to be arrested, what about the relationship between South Africa and Sudan? What about our soldiers that are in Sudan? What about all of those things? But the question I am asking has to do with, we understand that the Rome Statute, in the case of South Africa, was domesticated and into Act number 27 of 2002 and became an enforcer of the Rome Statute. The question is, why disregard your own legislation for political expediency?
So Andile is right that there was a tension between the two. What you had was a decision maker of a court that if they acted would have compromised South Africa's foreign policy agenda. There's no doubt about it. One of the reasons, and one of the reasons why I said government didn't have its hand on the tiller and didn't have control of the job, was they should have known this 3 or 4 months before. They should have known that they've domesticated the Rome Statute. And they should have known that that means they don't have much room for maneuver, which means they should have acted in a legislative way. They should have revised that statute that allowed for somebody to come in. That's what happens in the United States, for instance. The legislation allows them to allow people to come in for UN gatherings and leave. That was the argument that government wanted to put, that al-Bashir was a guest of the AU. But your legislative apparatus did not allow you to do that. If you knew that 3 months in advance, why the hell didn't you fix it? That's where the problem lies.
Luando has been, I want Luando to make a comment because I want to go back to, on this very issue, I want to go to Lawson.
So I think this is an area in law that Andile is touching on with various themes, right? You have requiring judges to think of political consequences. You just have to ask yourself, is that part of their job to think of political consequences? And also, it's a policy within the judiciary that they apply their minds to a case, and if a matter is political, there's something called, deferring to the executive. So there's certain legal concepts that deal with cases of a political nature like this, but at the same time, I think the question should be, what bearing should political consequences have when you're trying to judge a case?
Lawson, you have to come in there. I thought that's a very important issue that we should pursue with you.
Yeah, absolutely. I mean, I think as I said earlier, the courts are obliged to apply the Constitution and the law, and they cannot take into account political considerations. I mean, in as much as we say that there should not be a judicialization of our politics, I think it may well be a greater threat to our Constitution if there's alternatively a politicization of the judiciary. And I don't think we would want the courts to take into account political implications of decisions that they may make. They must simply apply the law as it stands. And whatever the consequences are, as Adam Habiba said, government should have been aware of this months ago and had it within their ambit to be able to do something about it. The fact that they failed to do that, they then have to live with the consequences of that.
Prof, South Africa is a signatory to several the UN Charter, several other bodies, the UN Charter, and 7 others that are besides the Rome Statute that I've counted here. So therefore, South Africa has to do. For instance, I made an example, a very good example, an example I thought was very good to somebody. If you join the nuclear treaty, you must abide by the rules. And that is why there is this problem between the West and Iran. Because Iran joined the nuclear treaty, but they don't want to abide by the rules.
So I think that's right. If you enter into, voluntarily anyway, if you enter into a whole series of international treaties, then you're obliged to stand by them. That's the commitment you've made. And that's the big question that they have. Now, in this case, by the way, the South Africans have signed to the ICC, but they've also signed a whole series of agreements with the AU, and those two come into conflict with each other. But as I say again, that's not for the judges to resolve. The politicians should have resolved that themselves. They should not have put the judges in this position that they did. And the fact that they hadn't done it meant that they were not on top of their job. That's why they got into the mess that they did around the al-Bashir case.
Can there be, Londo, total independence of the judiciary? I think we have alluded to that there might not be.
So when you talk about independence of the judiciary, I think we have to understand that we're talking about it at two levels. There's an institutional level, and there's the level, a more personal level in terms of the judge himself when he's making the decision. So the institutional level is in terms of how judges are appointed, how the judiciary is funded, and all those things. So when you talk about financial independence, there can be to a certain extent, because at the end of the day, it's taxpayers' money that is distributed by the government. And then in terms of how judges are appointed, there is a measure of checks and balances in terms of appointing the right people, choosing the right candidates, and all of that. And then at a personal level, you have to ask whether that judge is being impartial, if there are any other influences, and all those things. So you have to look at it in the layers, and I think there is a good measure of independence, whether it could be absolute. For instance, there'll still be a financial reliance, but you can put measures in place to make sure that, for instance, the judiciary isn't punished by having, its financials, cut off or something like that. So, yeah.
Well, we actually would like our viewers to understand that we never were absolute around the issue of the rule of law, because we know the case is still ongoing. And we have been saying, Prof, that it is a good thing that the government has actually appealed this decision, because it demonstrates the importance of the courts.
Absolutely. You see, this is why I don't think we have a constitutional crisis. I mean, for instance, the president has gone to court on multiple times. And on a number of occasions, the courts have found against him. And he might have appealed the case, but he's always played it by the rules. And you might say he's got other reasons and rationales for doing it. But frankly, it is amazing how much we've actually deferred. And even politicians have deferred and played it by the rules. So do we have tensions? Absolutely. Are we likely to have more tensions? Absolutely. Are we likely to have politicians say very stupid things every now and then? Absolutely. Does that mean that we're in a constitutional crisis and our judiciary is now under threat? I'm not so sure we've reached there. And I think the fact that the government has appealed, and the fact that the courts, the judges stood up and said, we'd like a meeting on this, are both examples of the establishing, drawing the line in the sand, which is good for our independence of the judiciary.
You want to weigh in there, Lawson?
Yes, I think our court system is very robust. The fact that we have a functional court system, an appeal system, as we've seen in a number of these cases where the appeals process is being utilized, means that individual judges will make errors. They are, after all, only human, and they're not infallible. But the system is designed to take account of those things and to provide checks and balances within the court system itself. And I think that system works very well. The one other example I want to use, a government and politicians are complaining about the fact that there's sort of a judicial overreach into the realm of the executive. I want to take one example of a court case this week in the National Lotteries Board matter between Ituba and Gidani, where the award of the new lottery license to Ituba was challenged by the previous holder of that license, Gidani. The court found that the Minister of Trade and Industry had not applied his discretion properly in finalizing the license for Ituba, and declared that awarding of that license was therefore invalid and unlawful. But the court deferred to the discretion, the policy discretion that lies with the Minister of Trade and Industry, and said we will suspend this order for a period of 1 month to allow the minister to exercise his discretion now according to the law and the regulations that surround it. So the court has said this is unlawful, but the minister must fix it. The courts are not fixing it. They're deferring to the policy prerogative of the executive and allowing that to happen. And I think that's a way in which the courts play their role very well and allow the executive to also play its role.
Well, let's hold him there for now and go for another commercial break. But before, remember, you can be part of this discussion by calling our studio numbers that are on the screen right now. And you can also tweet us at Recourse and send us an email on sabc.co.za. We'll be back right after this.
Everybody wants to look like Superman, and unfortunately, nothing in a bottle, nothing in a capsule form will give you muscle. It's hard work, in fact, it's smart work.
It is time sportsmen and women realize that supplements may be contaminated with banned substances and that this can affect their health in the long term.
The only way a supplement can be regarded as safe from banned substances is if the entire supplement batch is tested and cleared by an accredited anti-doping laboratory.
Join me on Health Talk every Saturday morning between 9 a.m. and 10 a.m. as we unpack current health stories.
Welcome back, and thanks for staying with us. We are still discussing the independence of the judiciary following concerns that the country's judges are under attack by politicians. Let's take this call from John from Cape Town. Is John there? Is John there? John is not there. Let me come back to you. There's been talk about judicial activism by judges who make statements at private functions. Remember the statement that was made by Deputy Chief Justice Dikgang Moseneke, and also statements made by Judge Masipa in the United Kingdom. But shouldn't judges take part in public discourse?
So I think, again, as much as we say the way politicians engage in public discourse, judges must also be mindful of their particular role and that it can have consequences. I do think that when people say something in a private domain and then it has public consequences, it was a particular moment. It was a big controversy in South Africa, and so people took statements in a private gathering and put it into the public domain. I would have liked to see the Deputy Chief Justice being more circumspect in his private comments, especially if he knew the kinds of people who were at that party would have been able to report this over. However, I do want to say this, that I'm not opposed to judicial activism. I would love the idea of judges pushing the boundaries, so long as the boundaries are to the broader spirit of the Constitution itself. So when judges act in the spirit to push the boundaries of the legal process, to act in favor of poor people in our society, around health or around education, I love that idea. I think that's fantastic. They should be pushing those boundaries, provided it's within the parameters of the very spirit of the Constitution. That's what happens. That's what happens in any constitution anywhere in the world. What you see is constitutional courts, how they interpret the Constitution in 1789 is very different to how they interpreted in 1950 and how they interpreted in 2015. That we must see happen. And there is a role for judicial activism in that.
Let's take this call first. I know Londa wanted to say something from Chris. Chris, good afternoon and welcome to Rights and Recourse.
How are you, friend?
Fine, thanks. How are you?
I'm okay. I'm a little bit worried. The majority of the people in South Africa knows nothing about the law as it stands now. And we are saying the politicians who must worry. We had soldiers who were in Sudan, and there are many people who are there to visit. I don't think the Sudanese would have been happy with the way if the president was arrested and they were going to congratulate and say all South Africans go back freely. It was not going to happen like that. So I'm worried when it is said that judges is not their job to look at these instances where people who are there cannot come back easily if their president is arrested in South Africa. Why don't they have to let that to the politicians? It means if you're a judge, you don't consider all your people who are outside the country, who are on visits, like so our soldiers who are working there, they can't be allowed to come back freely if their president is arrested. You see when he arrived there were a lot of people who were waiting for him to arrive there at home.
Thank you, Chris. I think that Chris point. Thank you, Chris. Thank you. I think the point Chris is making is a point that was made by Andile about our soldiers that are in Sudan. But when you declare war, you don't first say, "Let all my people come back to my country before we fight."
So again, my answer to that is twofold. Firstly, again, as I've said before, the reason we got into the mess we're in was because government didn't have its act up front. If that was the issue, Government should have anticipated that 3 months ago and acted accordingly to make sure that it didn't create the crisis that it did. The fact that it didn't now means you're dumping that responsibility on the judges, and that's not what their role and responsibility is. Second, even if that was the case, what one had to do is think imaginatively around the question. I think sitting down with the heads of state, with al-Bashir himself, and explaining the set of situations, we could have managed this in ways that didn't mean we had to actually ignore a formal court order. That's what we effectively did. And that's where the problem lies.
I know I want to come back to you, Luanda, because John is back on the line from Cape Town. John, good afternoon and welcome to Rights and Recourse.
Yes, good afternoon. What I wanted to ask really was, we understand that the judges have to weigh in on arguments which are put on their table. But at times also they must check if the law they are advocating is implementable. Because really, South Africa can be the first country to arrest a sitting president in the whole world, knowing that this world is getting more divided. There is a lot of terrorism. At the end of the day, if we have South Africa having enemies of the outside countries, the poor are going to be affected again. Look at Kenya having problems sending their soldiers to Somalia, and now they are having all those malls attacked because of that simple problem where they really wanted to help the people of Somalia liberated, but they are paying for that, and who is paying now is the people in the street. So really, I think it wasn't a possible thing to arrest a leader of another country. Where I also have a problem, you remember when the courts also ruled that the EFF people mustn't be taken out of court, out of the parliament. I think they were also supposed to give an alternative there, because we have a problem of unruly people who don't want to stand up and go out on their own. And
Thank you, John. You've made a point. I think you've made a point there. John was talking about you cannot arrest a sitting president. I see earlier you spoke about, Luanda, you spoke about an example of you spoke about an example of America, Abraham Lincoln you quoted. But I seem to remember the Americans going to Panama to go and arrest the president of Panama.
So I think the comment that I made earlier during the break is, it goes back to our discussion on the rule of law. It can sometimes take centuries to build the ideal rule of law that we want, and I think we're in that process. So the Lincoln example is that people often forget. I mean, he's revered and well-respected, but people often forget that he actually outrightly disobeyed a court order. He did not implement it. He had suspended an essential human right during a time of war, and the courts found it unconstitutional. And he issued an opinion of his own because he felt that the court's judgment did not meet the circumstances of the time, didn't address the circumstances. So there are a number of occasions throughout history where this kind of incident has happened, and it gives us the opportunity to have these discussions and to strengthen the rule of law. So that was the context. Yeah.
I hope you're not saying that Jacob Zuma must be Abraham Lincoln and not disobey the law.
Lawson, let me go down to Lawson in Cape Town. Lawson, you've heard what Luanda said around the issues regarding President Abraham Lincoln not accepting a court order, not pushing forward with the court order. Is that an answer to what we have said earlier, that the independence of the judiciary is not absolute?
Of course it's not absolute, but you know, the courts have a very, as I've said before, the courts have a very clear mandate under the Constitution, which is to implement the Constitution and the laws of the country. And you know, I think you know, this was an issue that came up, for example, questions that came up during the interviews at the Judicial Service Commission this week, when the JSC was interviewing candidates for the Constitutional Court and the Supreme Court of Appeal. And I think it was the Minister of Justice who kept asking the question of judges, judges as to, should judges take into account the implications of their decisions. And I think the phrase he used was, should you, make a decision knowing that the heavens may fall. And the judges, all of them responded by saying they cannot take into account extraneous circumstances. They have a duty to uphold the oath of office, to uphold the Constitution, to uphold the spirit of the Constitution, indeed. But to go beyond that, I don't think is within the remit of judges, and I don't think that it's a practice that we would want to encourage within South Africa. I also want to pick up on the point that John made about Parliament and the EFF. I think, again, there the courts were very specific in making a finding to say that the power that existed, or the provision that existed within the Powers and Privileges of Parliament Act was unconstitutional because it offended against this principle of separation of powers. It didn't say that Parliament can't enforce its rules and cannot seek to restore order in the House, but it must do so in a manner that is consistent with the principles in the Constitution. And I think that, that's the issue that we must keep coming back to, that we are in a constitutional democracy. It is the values and the provisions of the Constitution that must guide the exercise of public power.
Well, we're still talking to you. We're still taking your calls on 011 714 5497 or 5498. You can also email us, email your thoughts to Rights and Recourse at sabc.co.za. Alternatively, follow us on Twitter at Rights Recourse. Stay with us.
We live in a digital era, and the number of Africans with mobile phones is rapidly increasing.
Twitter use is predominantly being done on smartphones. This is a very African phenomenon.
Here, there are constantly new innovative ways to make the internet more affordable. With that, we're seeing protests against governments proposing methods to limit access. On Network, we give you information about all of this. We also have new computers, games, and robots.
Join Siphumelele Zondi on Network every Sunday at 19:30 CAT.
Welcome back to Rights and Recourse as we discuss the judiciary and the spat between the judiciary and the ruling alliance. Let's take this call from Musha from the Eastern Cape. Musha, good afternoon and welcome to Rights and Recourse.
Thanks very much. I would like your guest to assist me on whether which easiest way they can recommend when South Africa want to pull out of ICC, the Roman Statute. Secondly, is it justified for a judge to say, like for instance, referring to the DA before election issue, that the DA sent in SMS to 1 million people saying President Zuma is a thief, and the judgment, that whether it was in the Western Cape, declared that it is within their rights to do so. And lastly, is it AU took a decision, for instance, not to cooperate with the ICC. AU is a continental body. Now, how would your guests advise me on how they take between the two?
Thank you very much, Musha. Musha's comment there, I think the first one is the DA's SMS, but that was appealed and the Supreme Court of Appeal ruled against the ANC. The other one is the AU is the AU said they are pulling out. It's not the AU that was pulled out of the ICC. It is the individual countries who joined voluntarily.
So again, I mean, what he's pointing to is the contradiction between these two international commitments we have. And again, I think the only way you could have done that is if you had been on top of your job and had addressed it appropriately a couple of months back. You wouldn't have been in the challenge that you're in now. That's how I would have dealt with it. Don't push the responsibility that should have been the politicians on the judges. It's not fair on them. It's not their responsibility. The politicians should have acted appropriately many months before the actual summit. The other case, the other question was about the ICC. I mean, what South Africa can do is deliberate. Is entirely entitled to come out of the ICC. I've written on a number of occasions saying I think that's a bad idea. I think that there's problems with the ICC, but I'd much rather push the ICC in the boundaries of the ICC statute so that it covers broader boundaries, it is more equal, it applies to all countries. I'd rather do that than withdraw out of there, because then the only people who will suffer are communities on the African continent whose rights are being abrogated by political thugs in many parts of the continent, and they then don't have a recourse to go somewhere to represent their interests.
Lando, you've been burning to say something. I'm sorry, I've been keeping you on the...
I think if the caller was still on the line, it would be interesting to know if he actually read the judgment that he referred to regarding the SMS case, and if he was more specific as what he didn't like about it, what didn't make sense to him about it, rather than a general, they found this and I don't like it. So that would have been interesting to know if he actually read the judgment and the reasoning and what it is, other than the outcome that he did not appreciate. And then I guess back to my earlier point is that when I made the Lincoln example, it's more about that republics go through what we are going through. It's not new. And being an optimist and also looking at comparative constitutional law, knowing that republics do enjoy these trials and they do survive.
Lawson, let me go back to you. One of the problems I sit with here as active secretary of CASAC, one of the things that people don't really understand is that legislation and the Constitution are actually living documents, and these can be, the judges are sitting and looking over and poring over these documents all the time. Did you hear me?
Indeed, they are. These are living documents. Laws get amended all the time. There are court judgments that deal with the interpretation of legislation and interpretation of particular parts of the Constitution, and that's what we refer to as the jurisprudence of the courts. So these are not static documents. They grow with time. They evolve. The interpretation evolves over time. Laws get amended. The Constitution gets amended. The Constitution has been amended, almost 20 times in the almost 20 years that it's been in existence. So these are living documents that have to reflect the realities and the conditions that we live in. But there are proper processes that one goes through in order to do that. And the responsibility of the courts is to implement the law as it stands and apply that law to a given set of facts that is presented to the courts. It's a simple interpretation that the courts go through. In some cases, different courts may come to different conclusions based on the same set of facts and applying the same laws to the same set of facts. But that, as I said earlier, is part of the robustness of the institution of the courts, and hopefully at the end of the day, we get the right result from the courts many, many more times than we don't.
Let's take final comments from you, Lwando, around this issue of the constitutionality or the constitutional role of the judges or the judiciary in South Africa.
The aspect that I'd like to come in on is that there are various ways to challenge the court system, the judiciary, if you're disgruntled. There are ways where, another example of the US is where, they have this ongoing debate about abortion. Certain states do not want to implement the Supreme Court's judgment. So what they do is that they legislate pieces of legislation of their own, allowing an abortion, even though the Supreme Court has said no. That's a way of playing within the legal sphere of drafting this piece of legislation and hoping that the matter will go back to the Supreme Court so that it can be looked at again. And as you said, the Constitution is a living document, so you never know if over time feelings and things will change. So there are many examples where people try and test the court's powers and their limits, and I think that is a it's good for a democracy. I appreciate it.
Prof, your last minute. The one thing I wanted you to include, I've been objecting to the fact that there are countries sitting on the Security Council who are not signatories to the Rome Statute, and yet they make decisions as to who should be persecuted or prosecuted by the ICC.
And I think that's outrageous. I've said this before, and I say it again. I think it's particularly outrageous that countries on the Security Council that have not ratified the Rome Statute are using the very institution established by the Rome Statute to advance their political agendas. That, however, means we need to challenge that. It doesn't mean that we should ignore court orders in our society, and that's why I still hold that we should have abided by the court order, and there was nothing that we could have done. If we had been on the top of our job, we wouldn't have been in a mess in the first place.
It's an exciting thing, and I think it's going to be with us for some time, and I think it's exciting times. We live in exciting times, say the Chinese.
Absolutely.
Well, we've now come to the end of today's show. Let me thank our guests for making time to be with us. Please join us again next Sunday for another live discussion. Remember, this show is repeated at 10 o'clock tonight and at 5 a.m. tomorrow morning. From me, Dumilo Mateza, and the whole of the team, it's goodbye.